The courtroom opens with tension as People versus Savannah Bradley is called. She's facing charges of retail fraud and meth use, two misdemeanors that could change her life. The judge's tone is calm, but firm. Will this young woman's honesty today work in her favor, or will her past choices catch up with her? The air feels heavy already.
To count 3, retail fraud in the third degree, the 93-day offense, and count 4, use of methamphetamine, a 1-year offense. Upon her successful plea to those charges, counts 1 and 2 would be dismissed. There is a sentence agreement of no 7411.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Savannah Bradley.
All right. And I should say on the sentencing form, there's a sentencing judge waiver, but that doesn't need to be filled out because it's my case.
Yes, Your Honor.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes.
All right. The first is count 3 of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine should be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Count 4, also that you'll be pleading guilty to, is use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of retail fraud third degree, how do you plead?
Guilty.
To the charge of use of methamphetamine, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal up?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of these offenses?
Yes.
July 20th, 2025, at the location of 372 or 3749 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Target store that makes you think that you're guilty?
I put items in a bag that I scanned the bag, not the items.
Okay, so it was a bag from the store?
Yes.
Okay, and you put items inside to conceal them?
Yes.
Scanned the bag, but didn't scan the items inside?
Correct.
You did that intentionally?
I did.
And you tried to walk out without paying for them?
Yes.
Store was open to the public at the time?
Yes.
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you put inside and didn't scan, these were items that were offered for sale by Target?
Yes.
All right. On that same day, did you have methamphetamine in your?
Here, Savannah pleads guilty to both charges. The judge makes sure she understands every word. No trial, no appeals, no second chances. It's a legal moment that many overlook, but it defines her future. This isn't just paperwork, it's her freedom on the line. Do you think she's pleading from guilt or from exhaustion with the system?
Nor would the court be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
What's that?
Because it's so satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. 14A1 probation. Sentencing in this matter will be.
December 10th at noon.
No, she's in custody. Thank you. Sentencing, November 12th, 2025. 10 a.m. Before me.
Your Honor, may I address bond forward?
Be disappointed if you didn't. Go ahead.
Your Honor, first of all, we had been wanting to ask for a reduction in her bond that is currently set up. Miss Bradley has not seen her son for about 80 days. She was in custody of Wayne County for around 75 days. Her son is currently with her dad. She needs to get him enrolled in school before CPS starts getting involved. She is okay getting released on GPS tether, on any alcohol tether, and do any sort of testing that Your Honor decides to order. She's even willing to be put
She
on.
didn't do that the first time, though.
That was,
I mean, the reason that she's in, she had a PR, she didn't comply with community correction and didn't appear.
yes, understood, Your Honor. And she does have a letter that she wanted to share with you. I've already shared it with the prosecution. We could provide it to Your Honor if you would allow us to. She does apologize for that.
So you want me to stop in the middle of everything and read a letter?
No,
Oh, okay, go ahead.
I mean, I guess I can summarize it to you. It's a really heartfelt letter. She's saying in it that she apologizes. She wants to be able to get back to her son. She's been far away from him enough. She is interested in rehab. I would have asked for her.
Now Savannah's attorney steps in, pleading for compassion. She's been in custody for 75 days, separated from her son. You can hear the desperation as she asks for another chance to reunite her family. But the judge isn't moved easily. Can regret outweigh a record of broken promises? The balance between law and mercy is razor thin here.
Sorry, yeah, I just did the 75 in Wayne County and I got and came here right the same day. I had to move from my current house to my dad's house. My boyfriend left me when I was in Wayne County. So I got to get him in school because it's about a 30-minute drive from my dad's house to a school that he's having a hard time with. And I just need to get him enrolled over there so he can get in there. His dad currently don't have power at the house. So that's why he's staying with my dad. And he's just having a hard time getting him back and forth to school.
Oh,
I'll do
wow.
anything.
Pardon?
I'll do anything the court asks.
Well, ma'am,
I know I messed
gave
up.
you the
I know.
Yeah,
I know I
really,
did.
you messed up.
I did.
Big time. And now you want me just to give you another chance to apparently mess up, and you've not received any treatment. You've not received anything, which was part of the reason why you ended up with the bond that you did, and you ended up incarcerated because you were using.
I know.
So, and I'll be honest with you, and I mean, I don't mean to be harsh about this, but I think it's true. I don't know how good you do your son if you're using, and you've done nothing to sort of alleviate that part of the issue.
I don't want to use anymore. I haven't. It's been 80 days.
No addict
I
that
can
comes
do it.
before me wants to use.
I'm not going to.
Ma'am, how many times have you made that promise to yourself or to others?
The judge's patience wears thin. You've done nothing to fix your addiction, he reminds her. Savannah insists she's clean for 80 days, but the court has heard it before. Addiction meets accountability in real time. Would you grant her another chance? Or do you agree with the judge that talk means nothing without proof of change?
75, like 85 days. And I know I can
Because
do it.
part
I
of that
don't want
we've
to.
had you.
And I'm glad that Wayne County took me because if they didn't, I probably would still be using. But I haven't, and I feel good that I haven't.
Anything else? I don't need a response from the people. Motion for bond reduction is denied. I may reconsider it after she's evaluated by probation, but at this time, I'm going to deny the request. Bond will continue.
Understood, Your Honor. Thank you.
Thank you. Court calls the case, People versus Lydia Bevere Whitfield.
Good morning, Judge. Christopher Quinn, appearing on behalf of Ms. Whitfield.
Your name?
Lydia Bevere.
We're just asking for one more BCC, Judge, for discovery purposes.
Probable cause conference in this case will be adjourned November 20th, 2025, 9 a.m.
Could I get the 13th, Judge?
Why?
I'm anticipating potentially having a trial on the 20th.
Can give you the 13th, but when you can't get out of here that day, don't yell at me.
Understood. Thank you.
November 13th, 9 a.m. Court calls case, People versus Douglas Brown.
General Order, Assistant Prosecuting Attorney for the People.
Morning, Your Honor, Michael Vincent on behalf of Doug Brown.
Your name, sir?
Douglas Brown.
Thank you.
We need a prelim date, Your Honor.
Discovery is all complete. All right. And people would have their witnesses available. I think the last time, the 13th was a more convenient date for you. So people would have their witnesses available on the 13th.
I believe so, Your Honor.
Yeah, that phone though.
Preliminary examination in person, November 13th, 2025, 2 p.m. That is before me. On continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Denicia Charles.
With Savannah's plea settled, the courtroom shifts quickly through new cases, People versus Whitfield, Brown, Charles, and others. You can feel the pace intensify. Each defendant steps up. Each lawyer negotiates. Each story briefly unfolds. From bond hearings to adjournments, it's a reminder. For the court, justice never pauses. Case after case, name after name.
I agree with the adjournment initiation. I want to amend the bond to allow victim Brian to have contact with her mom. His mom, her mom.
If you submit an order that's stipulated to, I'm not going to have an issue.
And I also would agree to, there's a potential that we're going to dismiss count one, which is the child abuse. So I have no objection to the tether being removed. They're currently working with CPS, the mom and the victim. So we are both requesting that removal. They have allowed contact, no GPS tether, and I can put that in.
Put it all in an order.
Thanks.
How much time did you need, Mr. Durkis?
Like 2 weeks.
Probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond continued. Thank you, ma'am. Court calls case, People versus Cortez Bryant.
Good morning, Your Honor. Sam Bernstein for Mr. Bryant. I've lost my voice. It's gonna be a long day. I have like 10 PCCs.
Yeah, but it's kind of pleasant you lost your voice. Sir, your name?
Cortez Bryant.
All right, what are we doing? You're afraid to say anything now. Go ahead.
Can we please step for exam, Your Honor?
Yes,
Discovery is complete.
thank you.
I lost my voice. Obviously. I'm too tired. Thank you.
Would the people have their witnesses available? Well, I can set it for the 10th or the 13th.
Could I please have the 13th, Your Honor?
13th.
Yes.
People have their witnesses available the 13th. Preliminary examination in person will be set November 13th, 2025, 9 a.m. That is before Judge Barr. Or I'm sorry, 10 a.m. before Judge Barr. Bond will continue. Thank you. Court does call the case, People versus Rayshawn Dawson.
That's votes for people.
I'm gonna go grab.
Carmen, I got it.
Oh, okay.
Sam Bernstein, I can stand in for Ms. Foster Tucker for Mr. Dawson.
On behalf of Mr. Dawson on the case ending in 1437.
All right, your name, sir?
Rayshawn Dawson.
All right.
We are asking for an exam, Your Honor.
Well, are you both asking for an exam?
No.
You're asking
I'm
for.
asking for an adjournment, yes.
Okay, let me do the adjournment first. So probable cause conference in this matter, that being the 1437, will be adjourned to November 20th, 2025, 9 a.m. Bond will continue on that case. Okay. Then on the other matter, Charters on this side. And you don't have Mr. Foster Tucker's schedule.
The 13th looks better, Your Honor.
You don't know that.
I do.
You're just saying that.
No, Your Honor, I have her
You're
calendar.
just saying that. You have no idea.
I reviewed the calendar.
Because I was gonna set it for the 10th. You reviewed it?
She can make the 10th work as well.
She can? Then why
Yes,
didn't
sir.
you say that? Never mind, don't talk, because I don't want your voice hurt.
You're like, oh,
I'm no, what's funny about this is you're not having your, I can come at you all day.
wait till my bond arguments. Just kidding.
So what I'm gonna do, because would the people have their witnesses available to 10?
We'll try, Your Honor.
All right. What I'm gonna do, sir, is I'll set your preliminary examination in person, November 10th, 2025, 9 a.m. That's before Judge Balvo.
That's here.
That's here. Okay. That's on a Monday because of the holiday in the week. All right, bond will continue. Thank you. Court does call the cases of People versus Man Davis.
Best votes for the people.
Edward Lucas for Man Davis in 1167 and 1367.
And good morning, Your Honor. Assistant Public Defender Chinazi Kyriakin-Ruli on behalf of Mr. Man Davis. Mr. Davis, state your name for the record.
Man Davis. We all knew.
Judge, you respectfully request that I believe all the matters be set for preliminary examination.
Okay. So all discovery is complete on all of these matters?
To our knowledge,
Yes,
Your
Your
Honor,
Honor.
yes.
All right. And would the people have their witnesses available on the 13th?
We can try for that day, Your Honor.
Preliminary examination in all of these matters will be set for November 13th, 2025, 10 a.m. That's before Judge Barr on all matters.
Okay.
All right,
Thank you, Your Honor.
bond will continue. Is that it for Mr. Davis? So I won't see him again?
That is correct.
All right, take care.
I'll see you later.
All right. There in Zoom. Court calls the case, People versus Brandon Myers.
Take this call for you.
Morning, Your Honor. Michael
Yes,
Brady,
yes.
Assistant Public Defender on behalf of Mr.
Simpson.
Myers.
All right, your name, sir?
State your name.
Okay, he doesn't want to state his. Are you Mr. Meyer?
He's stating his name.
Okay, thank you. All right, what are we doing?
Your Honor, I have to ask for an adjournment. I went to see Mr. Myers. He was not available to be visited when I went to see him. I'll try again. Ms. Anderson from my office asked me to let you know there's a new case that's on the arraignment list today. I don't know if the court wanted to.
Today?
Yeah, he's on the 130 docket. It looks like it's a failure to return rental property, 1,000 to 20.
Okay. So what I'll do is I'll adjourn this to the 13th, 2025, 9 a.m. Bond will continue. Can you let the
You go to court on the
magistrate
15th, they got
know
adjourned.
to put this on the 13th? I think that's the
Oh,
date
no.
they'd land anyway. Thank you, sir.
I'll come visit you, Mr. Myers.
Well, I'll tell you what he said.
Pardon? Okay, he's got it. Court does call the case, People versus Kyle Wilson.
Chairman, that is on behalf of Mr. Wilson, who is approaching. Say your name for the record.
Carter Wilson. You're requesting an adjournment. Can counsel approach, please? All right. You're requesting an adjournment.
Yes, and a moment to address bond, Your Honor.
All right. Probable cause conference will be adjourned to November 13th, 2025, 9 a.m. As to bond.
Esteban, Your Honor, we were gonna be asking for an adjournment a reduction in the bond.
Here's where things heat up again. The defense fights for bond reduction, arguing Kyle Wilson deserves release to support his kids. But the prosecutor fires back with disturbing details, violent history, probation violations, and a terrified victim. The judge listens closely. Who's telling the fuller truth? Is this about second chances or public safety?
One of his other children, he usually stays with throughout the day, so he'd like to be able to get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has either he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case. The house that he could go to, his job is in Southfield. And then I believe your sister's address is
Oak Park,
Oak Park, and then the child's mother is in Westland. So really far away from here. Well, not really far away, but far enough. We can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it and be able to provide for his children.
Respond.
Your Honor, I'm going to strongly object to any modification of bond. In this case, he originally requested $150,000. He is currently on probation out of the Sixth Circuit Court for a GBH and DV conviction that he pled no contest to. As far as I saw on their website for that case, a bench warrant had been issued at this time. In this case,
Hold on. I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DV, GBH, and DV charge that he pled to.
All right, and there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was non-compliant?
I believe it's these. I don't know exactly. It just says order for bench warrant issued expedited on 10/22 of this year.
If I may, Your Honor.
On 10/22, so that was probably, go ahead, Counsel.
Yes, I believe that's his violation in Wayne. He is in contact with his probation officer. It's a good relationship with her. He knows about that. He's complying with that. He was about to be discharged November. He had done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete and is still doing more classes on his own, whim. He felt like it was helping him. And again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
He was doing everything he was supposed to do except have contact with the police and potentially commit other offenses.
Yes,
right?
Your Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about to finish another strangulation domestic violence case. And in this case, the victim is extremely terrified of him. She reported 2 different strangulation incidents, one that was out of county and one in Washtenaw. And that the defendant had left with her car for an extended period of time and she wanted it back to run errands. He became extremely upset, told her, "Stop telling me what to do or I'll beat your ass." He then balled up his fist, began pushing at her as if he was going to hit her, then pushed her to the ground, which caused her to fall on top of her son. He then put one hand around her throat, one over her mouth. While she's still on top of the child, strangled her. And when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing up, pulling away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I've had someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to probation for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victims, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point.
Yeah, but I'm presuming that some of that we can probably see because the door, there's physical damage to the door.
Yeah.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, Again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not in my review of the videos.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court's mind, based upon what I'm seeing, may be set too low. So I'm going to leave the bond where it is. I'll have his bond continue, but I'm certainly not reducing it.
Thank you, Your Honor. Understood.
Thank you.
The gavel falls as the judge refuses to reduce Wilson's bond, calling him a danger to the community. Across these hearings, we've seen guilt, denial, and raw humanity, justice in motion. Every word matters in this room. If this courtroom journey gripped you, hit like, drop your thoughts below, and subscribe for more real cases that reveal how justice truly works.